Well, this should come as no surprise. The Supreme Court has yet again punted on a Second Amendment issue, this time refusing to hear the case and decide if felons can own guns. Now, that sounds a little more shocking than it is, and we're going to talk about all of this in just a minute because I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, but I'm also a legal and political commentator here on YouTube. If you like that, hit the subscribe button and the notification bell so you don't miss any videos. Okay. All right. Here we go. The Supreme Court has declined to decide if felons can own guns. It's in the headline. This is from the Washington Examiner. It'll be in the description down below if you want to check out the article for yourself. We're going to go through it, but you have to understand, let's set the groundwork here. The last case the Supreme Court heard on Second Amendment issues was in 2010. And prior to that, it was 2008. And those are sister cases. So really, it's been 2008. If you really want to get technical, that was DC versus Heller. It was written by Antonin Scalia, and it's considered the landmark Second Amendment decision because there's really only three. There's McDonald in 2010, Heller in 2008, and US v. Miller all the way back in 1939. Despite the lies of Joe Biden saying that gun regulation existed from the founding and from the signing of the Second Amendment, that's not actually true. The first major firearms legislation at the federal level was the National Firearms Act in 1934, and that was a case decided in US v. Miller in 1939. And by the way, we as a people got shafted on that case, and I'm going to do a whole video on US v. Miller at some point in the future, but I have to try and avoid drinking bleach while doing it because you have to understand US v. Miller was decided with only arguments from the government. There were no arguments from the other side because Miller had died by the time this lawsuit got to the Supreme Court, and his estate wasn't paying the lawyer allegedly. And so like 4 days before the hearing, the lawyer just sent a letter to the court that says, by the way, I'm not going to show up. Not going to argue the case, and the court allowed it. If you want, this is one of the most politically motivated and politically unrealistically unfair decisions in the court's history, and it has curtailed a fundamental right in the most broad and ridiculous terms since 1939, and our Supreme Court is too afraid to take on the issue and figure out if this was even right in the first place, much less to find the outskirts of the right, which is what we're talking about here. A ban on felons owning guns. Does this violate the Second Amendment right to keep and bear arms? Well, at the onset, let's be clear. Yes, of course it does. Any restriction on a right violates the right. The question is not whether the right is violated, it's whether the right is properly violated. We have all sorts of violations of our rights all over the place, right? I can't call someone and threaten to murder them because that would be, even though that's my First Amendment right to free speech, that can transgress into the idea of threatening someone and depriving them of their right to life and the pursuit of happiness. They have the right to not be threatened at some sort of criminal level. So then we ask, is this reasonable? And we say, well, this infringement on my First Amendment right to say whatever I want is curbed by that person's freedom to be safe and secure in their person, all of these things. And so we can infringe on my right a little bit, just a little bit though, because that protection is still very strong, because the infringement is so limited in scope and because it implicates someone else's right and security. That's how this goes. Can felons own guns is a question of whether or not the restriction is reasonable. It is a restriction. It is an infringement. And I know shall not be infringed is written into the text, but our courts have just decided that those words don't actually exist. They say shall not be infringed, well, until we want to infringe it. I mean, that's how all rights have been. It's unfortunate, but that's the lay of the land where we are now. So, is this infringement reasonable? Well, let's look into this article because it's going to discuss the underlying cases, and you can determine whether or not it's reasonable. It's not. You can make up your own mind. It's not reasonable at all. On whether or not this is reasonable, it's definitely not reasonable. Let's take a look. Here we go. The Supreme Court on Monday declined to hear a case deciding if a lifetime ban on felons owning guns violates the Second Amendment. If you don't know how this works, if you get convicted of a felony, you're banned from owning guns forever. That's just how it goes. Unless you get a pardon and get your rights reinstated. It's a two-step process. And there are actually some non-felony crimes like misdemeanor or gross misdemeanor domestic violence cases. Those can also impose a lifetime ban, but those at least involve violence. They involve violence, typically domestic violence. Felony bans on gun ownership don't have to be violent. And that's really the issue here. This isn't just a simple matter of, look, this guy was using a pistol to arm liquor stores. Should he be able to have his gun rights back? Well, that's, maybe that's an infringement that people are okay with. The question here is whether or not, well, let's look at the case of Ken Flick. The court turned the case away in an unsigned order. It concerned the appeal of Ken Flick, a Georgia man who was convicted of a felony in 1987 for counterfeiting and importing cassette tapes. Cassette tapes. Cassette tapes died before this man's gun rights were reinstated. Not only that, cassette tapes died decades before this man's gun rights were reinstated. We had the amount of time that has passed since a cassette tape has even been seen in the wild is pretty heavy. But that's what he was convicted of. And though he was not violent, according to the information that we have, though no guns were used in the counterfeiting, I don't know, what would you shoot? The plastic to make the holes for the little reels in the cassette tape. I don't know how you would use a gun to do that. Though no guns were used in this, he is no longer allowed to own any firearms ever again, forever. He has a Second Amendment right to own firearms. And they said, well, but you copied some tapes, though, and brought them into the U.S., so we're going to have to put a hold on that gun ownership thing. Gun ownership is not a privilege. Let me be very, very clear on this, because a lot of dummies think that this is some sort of privilege that the government grants you. No, the Second Amendment demands that it's recognizing, that the government recognize your inherent right, endowed by your creator, your inherent right. It's in you, not granted. This is not a permissive thing by the government. Well, the government will allow you to own guns. No, you have an inherent right to keep and bear arms. And the amount of restrictions that we have on them now goes so far beyond what the founders had envisioned, and it's completely unjustified, as I talked about with US v. Miller. But let's keep going. While legislatures have wide latitudes to define crimes and classify them as felonies, they're not free to cast people out from the Constitution's protections, lawyers for Flick told the Supreme Court in their petition, arguing that the federal government cannot deprive people of their Second Amendment rights. The case attracted intense attention from gun rights groups, many of whom speculated that the court might accept the case following the addition of Justice Amy Coney Barrett to the bench. Barrett in 2019 wrote a dissent in an appeals court case in which the plaintiff made similar arguments as Flick. Barrett wrote that a Wisconsin man, Ricky Cantor, who had been convicted of mail fraud, was seeking to buy a firearm, should be allowed to do so because his crime was nonviolent. Quote, Barrett, absent evidence that he either belongs to a dangerous category or bears individual markers of risk, permanently disqualifying Cantor from possessing a gun violates the Second Amendment. Absolutely it does. Of course it does. Of course it violates it. And again, the question is that violation reasonable? No, it's not reasonable in this case. You've got non-violent criminals involved in non-violent crimes a while back. They've served their time. They're off of probation because restrictions of gun ownerships during probation is extremely common, is probably not going to be struck down by any court in the land, and is probably considered to be a reasonable restriction on Second Amendment rights. Look, you're a felon on probation. You're not going to get this because you have all sorts of things involved in that probation where a gun might complicate it. And so, no, you don't get it. That's the type of restrictions that the court can probably determine to be reasonable. The question is, he's done. he's done with his probation. He's done with serving his time. It's over. Now he wants to buy a gun to protect himself, to go hunting, whatever it may be. And there's a federal ban on his ownership forever. And that is a little bit much. The Supreme Court has not made a major Second Amendment decision since 2010. Court is currently reviewing a case from New York, deciding whether gun owners can carry their weapons concealed in public, a case that could have massive implications for gun ownership. But this isn't actually a Second Amendment issue as much as people are making it out to be. Whether or not you can conceal carry in public isn't a full Second Amendment issue, because if you can't conceal carry, can you open carry? There's another question. Can you carry a gun in public? Of course, you should be able to. Of course, the founders envisioned that people would be carrying guns in public for all sorts of reasons. Many, if not all of them, carried guns in public. It was part of culture. It's part of life. Guns are not the taboo things that we've made them into. And the taboo, restrictive nature of gun ownership is possibly contributing to some of the gun crime that we see out there. The same gun crime that is then used to justify these restrictions. Although it's important to note, none of these restrictions have been justified to the court. The court is just afraid. They're afraid to take on the issue. And it probably has something to do right now with the bevy of mass shootings that have been reported on in the media in 2021. I mean, Joe Biden so far is the mass shooting president. We've got mass shootings all over the place, and they seem to be heavy under Joe Biden's watch. Despite his tough talk on it, they weren't so prevalent in 2020. I don't know why they're so big in 2021, but as they are growing, the Supreme Court seems to be hesitant to take up the issue. Now, I know the court is supposed to be immune from this, is supposed to be above the whimsy of media and that sort of influence, but they're not. They're not, and that is probably informing their timing on this case and other cases as much as it shouldn't. So as long as the mass shootings just go ahead and keep up and keep being in the news, the court might be likely to punt on the issues. But we will see. We'll be following their New York case as well. There's promising stuff coming out of the Sixth Circuit with the removal of the bump stock ban. But as for the Supreme Court, all we see is fourth and long punts all day. And it's really, really getting frustrating. You have to remember, there are only three decisions on your fundamental right to own guns, a right that has existed since 1791. Or not, actually, it's existed much before that, has been recognized by the Constitution since 1791. And yet we only have three major decisions on it. Now, you can excuse the first 100 and whatever years until 1939 because there weren't federal restrictions on gun ownership. Let me be clear on that. None. There were no federal restrictions on gun ownership from 1791 to 1934. Only then do we get the first restriction in US v. Miller, and we get absolutely worked over by a completely ridiculous case in which only the government got to make arguments, and we've been stuck with the ripples of that decision ever since. But anyway, what do you think about this? Should felons, nonviolent felons, be allowed to own? Heck, should violent felons be allowed to own guns once their time is served? That's a realistic question. I would love to hear your thoughts down in the comments. Drop them. Let me know what you think. Until next time, thank you for watching. Peace. Peace.